Good morning and welcome to this morning's Knowledge Bank, a guide to major works projects and Section 20 legislation. This morning's session will be hosted by Ben Jarvis, Portfolio Manager at Benjamin Stevens Block Management. Ben will be taking your questions throughout the session, so please feel free to submit them via the Q&A button at the bottom of your screen, and we will try to get through as many possible at the end. This morning, Ben's going to be talking you through the major works process and how to smoothly carry out works involving Section 20 legislation. So without further ado, I will now pass you over to Ben. Good morning, Ben.
Good morning. I think that's working. Hello to everybody. So this is the first kind of one of these that I've done, so be gentle. And any questions that I can't immediately answer, I'll obviously go away, look into and get back to you. Obviously, it's important with this piece of legislation that we give correct answers to any questions to protect yourselves, protect your client's liability, etc. So today really is about looking at the legislation as a broad overview, a little bit of an idiot's guide as well. There might be people on the seminar that have been in property management for several years and know a lot about the legislation. There might be some little nuggets that you weren't aware of that it might just sort of help you sort of tighten up how you do things. The main reason as well is to look at ways you might be able to look at the process we put in place at Benjamin Stevens as a sort of small to mid-sized company. It might be similar. You might be a local authority, or you might be a sort of perhaps a letting agents that also do property management and are looking to expand into doing major works for your blocks, or you might already be doing it, but you want to make sure that you're doing it properly. Then we'll just sort of touch through sort of how we do it and how we tighten up the process, not only to help keep things on track so you can reset the clock at each stage, which hopefully keeps your clients happy, but it also helps you forecast when you might be due your admin fees. If you have a lot of projects coming up at one time, you can forecast to the bean counters, you know, when you're going to expect to have those fees coming in. So for a smaller or mid-sized company, that's really important for your bottom line. So without further ado, I'll click through these. Apologies if some of the slides go a bit quick because I'm used to doing it on Windows and I'm doing it on a new Mac. So some of these might pop up straight away. We'll see how we go. But anyway,
first I'll leave you to it, Ben. I'll pop back in at the end.
Right. Thanks very much. Okay, in a bit. Okay, so firstly, just to go over a brief overview of the Section 20 process. So under Landlord and Tenant Act 1985, as amended by Clara in 2002, there is a legal obligation to consult with leaseholders where works exceed £250 for any one unit, or £100 for any one unit where there's a long-term contract that exceeds 12 months. So you might have, as I found as I come into Benjamin Stevens, sometimes you might have developments where you have companies such as maybe Otis, for example, who like to put lift contracts in place for 3 years and then rolling for 5 years, and you have to go into the T's and C's to see just how quickly you can get out these contracts. But it's really important when you have contracts such as that, just to check the T's and C's and make sure that the value of the contract isn't exceeding £100 for any one unit, because if it is, you need to either renegotiate that contract ASAP or start to look at notifying leaseholders that their contribution exceeds for any 12-month financial period £100. As it says there, failure to consult leaseholders and any RTA or RMC could result in a penalty, which would be really that the client ultimately picks up the tab over that £250 or £100 per unit. So as you go up the scales of large scale works, a large block with some externals, the leaseholders only have to pay £250 each, and you can, I think, I can leave to your imagination as you go up the scales of what a job will cost, just what that liability would mean for the client, and possibly ultimately, I guess, the agent as well, where a client would wish to counterclaim based on the agent being sort of negligent in their duties. So, as I said before, we've put in a streamlined and sort of track process at Benjamin Stevens, and I've sort of brought along from other companies I've worked at, the experiences of either working in the office as an assistant property manager or as a property manager, experiences that I've encountered in the Section 20 process, particularly as the legislation has tightened over the years, and also where you find leaseholders are a little bit more clued up on legislation as well. So it's become really important over the last, I'd say, 2, 3, 4, 5 years to start to really make sure you get the process down pat, so you don't cause yourself or your clients any liability. So for us, having a streamlined process helps us to protect the client, and as I say, in turn, your company from any possible liability. It also means that you can be proactive through the process. It's not, you don't send out a notice and then it goes off out into the ether, and then you're so busy with the day-to-day or the reactive stuff that you do as a managing agent, that suddenly it will pop up a couple of months down the line that, oh, we didn't do the next part of the process. So it just means you can reset the clock at each stage. You can be proactive throughout the process, and that also then helps you with the client to justify your admin costs. If they're just asking, why are we paying, for example, 10% of the project fee to you as an admin cost? What do you do for that? And if you're only able really to say, oh, we send out a couple of notices here and there, and we might answer some queries from leaseholders, and we place an order, and if you can show them a full track process of shows that really what goes on behind the scenes, particularly as you get into the larger kind of jobs or lift replacements or those sort of projects, it really does help to justify why you're able to charge that admin cost. And of course, doing that adds a valuable additional revenue stream to your company. So for Benjamin Stevens or companies of our size, it's really invaluable that we look at things like major works, credit control processes, all of those kind of additional things that are aside from your day-to-day, company secretarial, those kind of things as well, that really help you give a full service to the client and show them that you're being proactive and you can cover all bases, but that shouldn't all be encompassed in one management fee, because as I said, for the smaller companies, I would say that to cover all your overheads just on your management fee, and continue as a going concern would be quite tricky. So you need to look at these kind of additional revenue streams to improve your bottom line. So just to carry on with it, for anyone that's signed in, I don't know if there's anyone sort of in the housing sector or local authorities, but I don't go into sort of the full initial procedures for the landlords in that sector, because you might actually need to draft a public notice as well before you enter into any of the particular notices to your residents, and especially before entering into any contracts. So just to let you know, if you wanted to look further at those public sector areas, there is a booklet on the Leasehold Advisory Service, and both Leasehold Advisory and ARMA have a wealth of information on there if you want to look stage by stage at Section 20 or any other processes. So I'd always advise looking there, because you can get some good advice that you can go to the clients or your residents with and advise them of best practice. So that booklet that's on the screen there is available on the Leasehold Advisory Service if you need it. So just to define a landlord for the purposes of consultation, that includes any person who has the right to enforce payment of service charge, as noted under Section 30 of the Landlord and Tenant Act. And depending on the structure of the leases and titles at any development that you're looking to do a project on, a landlord could be any of the following: the freeholder, the head lessee, resident management company or RMC, right to manage company or RTM, and also you do need to revise recognised tenants associations as well when you start any project as well. So that's important to cover too. Definition can also include superior landlords. So any planned expenditure by the overall freeholder of a mixed development will be subject to consultation if the qualifying criteria is met. So that's that £250 and £100 that I mentioned a couple of minutes ago. So just to touch on the laws and regulations, the law requires that leaseholders pay variable service charges. So that's pretty much any development, because you're not really ever going to have a fixed budget year to year. So whether they all pay an equal share or whether they're different percentages, the variable part will come into force, because from year to year, you will always look to adjust your budget or your estimate based on previous accounts and current spends. So really, it does encompass everybody before a landlord can carry out qualifying works or enter into one of those long-term post 12-month agreements that I spoke about a couple of minutes ago. Detailed regulations have been produced under Section 20 of the Landlord and Tenant Act, as amended by Clara, which set out the precise procedures landlords must follow. And these are the service charges, and similar regulations have been enacted in Wales. The format of the notices, though, interestingly, required by the regulations aren't fully detailed in the legislation. So they don't particularly say you must set your notices out in one particular way. But there are kind of bases that you should look to cover. And as long as you do that, you kind of are covered. But there aren't any particular, you must use this draft or this template, which is odd for such a sort of stringent part of legislation. But at the moment, that's kind of how it is. The requirements in the regulations are defined under 3 headings. So the qualifying works, which tends to be that £250 or over for an ELSE. And then the other 2 are for those contracts that you might have for lifts or any door entry systems, maintenance works that are over 12 months. So qualifying works is for £250 over, and qualifying long-term agreements and qualifying works under long-term agreements, they are for any contract over 12 months that any one leaseholder will pay more than £100. So just to touch on them individually, qualifying works are defined as works on a building or other premises that can be encompassed as works of repair, maintenance, or improvement. And it's important to note as well, the inclusion of improvement in the definition that was recently added to qualifying works doesn't allow a landlord to recover the costs of such improvements unless that liability for cost of improvements is included in the lease for that particular development you're working on. So that's really important actually to look at the type of project you're doing and just make sure that it is covered in the lease. Obviously, a lot of older leases, can be open to conjecture. So it might be that you just want to take a little bit of advice or agree with the client how you deem a certain part of the lease that you think is applicable. But it's definitely worth checking, as we probably do for most things in block management. We always sort of tend to refer to the lease and just make sure we're doing the right thing. So it's definitely important to do that for Section 20 works too. And when calculating the estimated cost, VAT should always be included in that so that you get to that £250 kicking in point. Another important point to note is that landlords must consult where works will cost any one leaseholder £250. So again, this goes back to the percentages that people might pay. So you might have a lot of blocks where everyone pays an equal share. That's fine, you know what your kicking in point is. But in a variable or unequal service charge contribution where maybe the top floor or penthouse of someone is paying, 12, 15, 20% of the cost, then the kicking in point is going to be lower. So we must consult all leaseholders if any one of them, so that, as I say, the highest percentage contributor would have to pay more than £250. So that's really important as well. If you haven't done so already, to look at your portfolio and look at the kicking in points, look at the highest paid percentage and work out from there what your kicking in point for Section 20 would be. So then the block managers or the senior manager teams can always have a good handle on what is likely to be Section 20. So you don't run into an issue where, in good faith, you've placed an order for something for a replacement of door entry or something like that, and you've done it with in all good intentions, but you actually encroached on the kicking in point without realizing. So it is a good thing to go through your portfolio. Just be sure that you know what your kicking in points are, where you have variable percentages that are paid. And as previously stated, if consultation is not undertaken properly, the landlord may not be able to recover costs over £250 per leaseholder. So qualifying long-term agreements, this is an agreement entered into by the landlord with an unconnected independent contractor for a period of more than 12 months. And although not spelt out in the Act, it is best to err on the side of caution. This includes ongoing contracts where there's no specific termination date. Landlords must consult where the amount payable by any one contributing leaseholder, so again, anyone with a high percentage is going to encroach on that £100 a lot quicker, so that needs to be checked. And as with qualifying works in a property with unequal service charges, as I say, the landlord must consult all leaseholders if any one of them would have to pay more than £100 in any one financial year. So as you've got the contract spanning across financial years, you need to make sure that £100 isn't across the lifespan of the contract, but is for your development's financial year end dates. If consultation is not undertaken, as with qualifying works, a landlord may not be able to recover more than £100 per leaseholder in any one accounting period towards the costs under the agreement. So again, as with the major works, it can start to spiral. If you have, for example, of these, as I say, going back to the Otis sort of lift style contracts where you're tied in for maybe 3 years and then it's 5 years and then there's a rolling sort of 20-year period, you really have to be careful that you can start to really spiral into quite a sort of hefty liability for the client and then maybe in turn on the agent as well. So just to give you a few examples of potential long-term agreements. So they'd be agreements affecting the building generally. So as we touched on, lifts, door entry systems, maintenance contracts, anything sort of over 12 months that you would normally list in your budget under sort of maintenance or PPM contracts, anything like that. Cleaning and gardening, insurances, although obviously they tend to run 12 months at a time. Utilities. Again, if you're looking as we are as a company, one of the other projects we've been doing is for electric and gas procurement, bringing the cost down and using one sort of a broker to drive the costs of the utility costs down. But obviously we have to be careful there in looking at the contracts that we sign, that we look to go year to year. Otherwise we could well encroach on that qualifying agreement. Contracts that are not qualifying for long-term agreements include contracts of employment. So if you have site staff, an agreement between a holding company or between subsidiaries of the same holding company, an agreement for less than 5 years that was entered into at a point where there were no leaseholders. So a new developer might put in a long-term contract of less than 5 years. That would be okay under the legislation, and an agreement for more than 12 months that was entered into before the end of October 2003. That's before they sort of tightened up the restrictions and they came into force. So anything before that that is still running, you would be okay. But again, best to check. And I would say for those anyway, it's best to look at renegotiating those kind of contracts that are 20 years plus in age. So just to touch on emergency works and dispensation as well, because there will be some projects where one day the roof may be coming in, or there might be something of real emergency that you feel you can't go through that whole process of first notice, consultation, tender period, second notice, etc. of 4 to 5 months of planning, where you really need to get these works done immediately. In that case, you can apply to the FTT, the first tier tribunal, and they have the power to determine on Section 20 matters, and that includes the power under Section 20 ZA to dispense with those consultation requirements if they're satisfied that there is a reasonable reason to dispense. So as I say, if it's something really urgent, like the roof is in urgent need of repair, and it really will encroach on the residents' livelihoods, or they might need to move into alternative accommodation, that sort of thing, they would judge on whether you can dispense with that. You can advise lessees that you are dispensing with the process and continue. The Supreme Court, in a case in 2013, set out its views on how tribunals should deal with the applications for dispensations. That's the Dejan versus Benson case, which is worth having a Google if you're interested in sort of reading through that and getting some further information. The purposes of the regulations is to ensure that lessees are protected from either paying for inappropriate works or paying more than would be appropriate. So the tribunal would still obviously look at the quotes and everything that's been put before them in order to go ahead ASAP to make sure that in dispensing with it, the lessees still have a fair and reasonable cost to pay. And in considering dispensation requests, the tribunal will focus on whether lessees were prejudiced in any respect by the failure of the landlord to comply with regulations. So, for example, in these last two paragraphs, the legal burden is on the landlord throughout, but the actual factual burden, if a case went to the tribunal, of identifying any prejudice is actually on the lessees. They have an obligation to identify what they would have said, given that their complaint is they've been deprived of the opportunity. So they haven't got those consultation notices and had an opportunity to give their opinion on whether they think that the works are necessary or recommend a contractor, those kind of things. So once the lessees have shown a credible case for prejudice, the tribunal then looks to the landlord to rebut that or give some sort of alternative argument as to why they need to progress ASAP. And the power to grant dispensation isn't all or nothing. The tribunal has the power to grant dispensation on appropriate terms. So it's not full or nothing. They can impose certain conditions on the grant of dispensation, including a condition as to costs that the landlord pays the lessee's reasonable costs incurred in connection with that application. So there might still be costs incurred by the landlord in that tribunal taking place in the first place. So that's why it's also important to make sure that before that application is made, it is absolutely necessary. Penalties for non-compliance. Whilst the main purpose of the consultation process is to seek the leaseholder's views on the landlord's proposals, the effect of the provisions is to limit the landlord's ability to recover if he does not correctly or fully comply. As we've spoken about already, if the landlord fails to carry out the full consultation procedures in the correct manner, they may not be able to collect or recover service charges above the level of the minimum amounts, £100 per year in respect of a long-term contract or £250 per leaseholder for works to the building. The landlord would have to cover those losses themselves. And in the case of an RMC or RTM, the consequences, as you see, could be disastrous, potentially rendering the company insolvent. And that means they're unable to fulfill their lease obligations. As managing agents, we of course have to both protect our clients from this liability and also ourselves, as any such breaches would likely result in a counterclaim against the agent for not fulfilling their duties as per the lease, and of course for their inability to follow known industry legislation for such work. So we know that Section 20 legislation exists, and it's not okay, regardless of the size of the company, to be kind of ignorant to those to that legislation and the parts of it, the steps you must follow. So we'll just have a look now through the process and the stages. And at Benjamin Stevens, we now use a specific timeline and process tracker to stay on top of our major works projects. This follows a 25-step process of variable. So some projects won't encounter the whole 25 steps. That will depend on, as I say, variables along the way. For example, that's from the creation of said tracker through to the various notices, the actual works themselves, snagging, finally completion and payment of a set of, for example, internal redecorations. Not only does this ensure that all applicable steps are being followed in any one project, but this also allows us to demonstrate to the client our proactive attitude towards the project, and that strengthens our relationship, the agent-client relationship we're always looking to build. And it also helps our company and your company, should you follow sort of a similar specific tracker, in the following ways. We can agree with the client our admin fee for the project, which can have a bigger positive effect on your company's bottom line. Across the industry, 10% is usually, other companies as well I've been at, is usually fairly standard. I know some companies do charge more, and it is likely, I would guess, regardless of where you work and what your policy currently is, that the project is likely to be dependent on the percentage you agree with the client. You might have a larger costed works, you might have a big window replacement, or a very big sort of high-end development that needs externals, for which you might have a surveyor or a project manager that is going to be managing that project. So yeah, that's likely that will mean that you will need to negotiate your percentage, but being able to show them that you have a specific process that you follow rather than just dipping in as and when, I think really does underline that there is a professional outlook to it. There is a holistic or seamless kind of transition from one step to the other, and it just helps you then, I think, be able to get the maximum you can as an admin fee, because we probably all know, having done projects before, that there is a lot, and there can be a lot to do in the background, and it isn't part of the day-to-day management of the development, and it shouldn't be part of any management agreement you have. So it is an extra task. There's a lot to do, and the company should be paid. And I have spent time since I've been with Benjamin Stevens having those conversations with clients, so they understand. And a simple analogy is like, as an agent, you expect to do the day-to-day, but then you might be expected to do COSEC or all these other stuff, or attend the AGM even though you're not secretary. Lots of things that really should be charged as an additional revenue stream, and the clients sometimes are a bit confused as to why that is. And I always say it's like going to Sainsbury's and doing your monthly shop, but then asking Sainsbury's to also get it off the shelf, put it in the basket, pay for it, take it home, put it in the cupboards as well. It's not their job. So you should be paid for additional things that you do that isn't within the annual management agreement. And secondly, it is better forecasting, as I said earlier, for when those said admin fees will be due. So once you get into that rhythm of using, say, a tracker, and you have several projects on the go at one time, you'll know when those fees are likely to land. And that assists with the company budgeting and your incomings and outgoings. And particularly, as I say, for small to mid-sized managing or letting agents, it's crucial to know when you've got those additional fees coming in, particularly where you're doing larger scale externals and those kind of projects that will bring in some nice additional fees. So just to go over broadly the main steps of the Section 20 process, and then I'll just come out of the presentation, just show you I'll show you the tracker that we use, and just go through some of the notices and the various sort of stages that might become applicable on any one project. So first, and really most importantly, firstly should be, if you have an RTM or an RMC, a client of any sort, freeholder, it should be going to them and discussing the project that you feel is necessary, and getting that approval from them in writing to actually start that file, start putting that file together and opening up any tracker or anything like that you do or might be thinking about using. From that, we will then start the process, get the tracker going, put all the initial documents into a new folder on our central drives at Benjamin Stephens, and we will generate the first notice to be posted out to all lessees and to any recognised tenants association as well. That's important to note. And from that is the first notice consultation period, which in the legislation is 30 days, but some companies may wish to give a few extra days for postage. So you may wish to give anything up to 37 days to allow postage on either side for the notices to reach the lessees and for any queries to come back to you. Although I would suggest in this day and age, most queries would come into you by email anyway. So if you're wanting to really tighten it, we don't tend to at the moment, Benjamin Stephens, extend it past 30 days because we want to keep that streamlined there. And it's very simple if someone has quite an urgent query or some kind of question on the project that, and as I say, in this day and age, you should be able to email that within seconds. So we don't feel at this time that if we extend it by a week on each notice period, you're then extending it by a couple of weeks, and you're starting to sort of lose sight of the process. So upon ending of the consultation period, this is really where you should start to get tenders. And I know it can sometimes with certain projects, you might want to get an initial flavour of what something might cost for the client, which then starts the conversation about starting the project. But ideally, you should know as we said about the kicking in points earlier, you should kind of have a fair wind of what might encroach on Section 20. Start the process and then go through a proper tender period. You're then able, if the tenders come back and the lowest quote or the quote that you wish to go with is under that kicking in point, then you can write out and advise lessees that you're stopping that process. It doesn't need to continue, and that you're going to, on instruction from the client, place an order with the successful contractor. So I think it is best to always try to hold off getting any kind of tender or quote until the end of the 30-day consultation period. What we also like to do, again from previous experience, it tends to work well, is to use a specific email inbox which we keep as a sealed tender. So we asked our contractors, when we send them all the scope or the specification, all the information surrounding the project, we ask them to send it back to a specific email address at Benjamin Stephens created for major works tenders. If it's sent anywhere else, it's not accepted. And those tenders aren't opened up until the end of that period. So we can demonstrate on any challenge that we have followed the process correctly, and we have had no involvement in the quotes or the estimates with any allegedly connected contractors or anything like that. Everything's been done, sent out into the ether to the contractors, and it hasn't been checked until that deadline date that has been specifically given to contractors. So that's something worth noting, something you might wish to look at to additionally protect yourself and your clients from any possible challenges. Then of course would be a discussion of the tenders with the client at the expiry of the estimate period, which will then lead to the second notice and the advice of the estimates, notice of estimates that you have received. And from that is a further 30 days consultation period. Again, you might wish to extend that, but as I say, we don't at the moment do that at Benjamin Stephens. On from that, we would then look to award the contract based on the client instruction and advise residents accordingly. However, this is where some of the variables of the process sort of come into play. You may wish, or the client may wish, to go with a more comprehensive tender or a better quote that isn't the lowest. In that case, you do need to send a third notice to lessees to advise them who's got the contract. And of course, within that, if you already know, you can start to advise of start dates, any particular applicable information, welfare areas on site, those kind of things. But you have to advise via a third notice as to why, and give as many reasons why you have chosen that contractor and not the most competitive estimate. An important point to note, if you weren't aware, the third notice doesn't carry a consultation period, so you don't have to send that out and wait another 30 days. You can send that out, advise the reasons why, obviously invite the right to reply, but there is no consultation period. If you're not sending the third notice and you are going ahead with the lowest quote, then you can start to send works information out to the lessees as you would have done within the third notice, who you're placing the contract with on the client instruction. As I say, any welfare information, or how long residents might be on, workmen might be on site. And then we go into stuff that would be done in the background, the pre-work arrangements. And at this point as well, if not done so already, it's important to have discussions with the contractor and the client as well about the schedule of payments, how they're going to be paid. And regardless of maybe how you structure it, whether it's, half up front for materials and workmen, whatever it might be, or lower percentages, it's always important to have a retention at the end of at least 10%. So you have some recourse there if you do the inspections or a lessee contacts you with any snagging issues. You then still have a retention to ensure that the contractor's return to complete the works correctly, to enable you then to release that retention payment. As I say, then after the works, you'll be looking to inspect that, or for any project manager, surveyor, client to also inspect that on site with you and pick up any snagging that the contractor needs to do. And then once that project is then finally complete, you can release that contractor retention payment and also look to get your project admin fees upon successful completion of the whole process. So before the Q&As, I'm going to find out how I get out of this spreadsheet. Bear with me and just go through some of, if I can bring this down and enlarge it. This is currently our process tracker, which goes from start to finish. So we create create this tracker. Obviously, we name it for the development, the client, get that all ready. We create, as you see in point 2 here, a new folder for the particular project under the applicable developments folder on our central drive. And then the next part is to get the client agreement and put that into the folder. At this point, then the block manager, once they have all of that together, the block manager can then, we do have some admin assistants in the office that will then assist in sending the notices and those kind of admin duties within the project out. So at this point, our block managers would send all that information across to our main office in Edgware to send out the first notice. So as you can see on here, points 5 and 6 are for the consultation itself and any returned observations. So in here we can note anything that's come back. So the block manager and the admin team can make sure we go back to anyone that has had any queries. So at this point, then number 7 is that sealed tender request that we ask people, the contractors, to send to a specific email inbox. Otherwise, their tender won't be considered. Another important point to note that isn't on the presentation. We also want to make sure that the contractors advise us of any CDM regulations on any project. So that covers health and safety, a certain amount of either work hours on site, work days on site, sorry, or work hours, or amount of workmen that might be on site. So if it encroaches on what the contractors would know would be known CDM regulations, same as when we know it will encroach on section 20, we would ask that the contractors advise us of any such CDM regulations to make sure we cover the compliance and health and safety as well whilst the works are going on. If need be, I can get some further information to people who want to sort of cover that base, but it would be more, I mean, within our, without bringing it up within our standard template to send the emails and letters out to the contractors for estimates. We do specifically cover that part to make sure that they are aware, as they should be, as a good contractor doing major projects, that they're aware of those particular CDM regulations, and that if the works are likely to encroach, they give us full details and factor those costs in accordingly. So when we go on to the second notice, all the applicable costs, including our project admin fees, surveyor costs, everything is included and is known. So we're giving the right information, and we're not missing any bases. So next will then be the open of the sealed tenders and discussion with the client, which then would lead to the second notice consultation and observations. And as we just touched on before, we then start to go through the award of the contract. The third notice here on row 21, if it's applicable. And then we start to get into other areas where we do again start to kind of earn that fee, where it might be that you don't have a reserve fund built up or enough of a reserve fund built up to pay for the project. So in that sense, you're going to then have to look at issuing an additional levy, either for the whole part of the project or for some of the costs. So that's when it starts to get into some of the background nitty-gritty admin stuff, where we earn the fee in working out what the levies will be, organising the billing and getting that sent out either with the third notice or with those that start date information. And it's important obviously to note on those notices that we would ask people to pay by a certain date to make sure it doesn't then delay the works and kick that project down the road, by a number of weeks. So as we've already covered, the start dates, pre-work arrangements, period of works, and as I say, that we get into the final stages of the project of making those initial payments to the contractors as agreed with the client, and then post works going into any snagging, writing out to the lessees to advise them that the initial period of works have been complete, but we would ask them to let us know of any snagging issues, anything that is applicable to the project. There might be some things that people write in to complain that this area hasn't been covered, and when we look at the scope, we find actually that was never included in the project anyway. So it's good to have lessees' input, but we need to make sure when we go back to the contractors that everything that has been sent into us is actually applicable to that project that's being carried out. And then we get to the final part where we can release our admin fee, where we can demonstrate to the client, and all the other stages are noted accordingly and signed off. We can release our payment, the contractor retention payment on completion of any snagging, and then an important part really as well for the projects and for the file for future reference to go back to is getting that client sign off. As much as we got the client approval to go ahead with the project, we also would like to get in writing that they're happy that the project seems complete, and we can put that all with the folder. Get all the information together step by step. All this information should be going into that folder on the central drive, and then that allows either myself or another member of the senior team or the managing director to sign off the project. And phew, we're done. It might have taken 4 or 5 months, but we've been able to track that process and kind of have some of these points do have particular timescales that we can either stick to or ideally stick to. So at each point we can reset, whether it's an Outlook reminder or whether it's some other way of resetting that clock, that each time it happens, we can kind of stay as on track as possible. So we can track not only for the client when the project's going to happen and keep everything as succinct as possible, but also when we're likely as a company. It might be the most important thing obviously is to protect the client and the company's liability to any issue and follow the process, but it is very important as well to be able to track that and get our fee when we feel when we forecast it's coming in. So I think it's really important, I think, if you possibly can, to look at tracking the process and, as I say, resetting the clock at each stage so you're on top of it. It doesn't just go out into the ether. It's a very important part of legislation. It's an important part of managing any development, upholding the leasehold obligation, so the lease obligations, and being a good managing agent to protect and improve the lessee's investment. So I think it's really important to demonstrate that as part of any project you are on top of it, and it is a proactive approach. I know block management most of the time is very reactive, but there are things that we can do all the time to be more proactive and keep things ticking over for our clients and for our residents. So just lastly, before I go to any Q&As, I just wanted to show, just so you can see the notices themselves. If you're unfamiliar with them or if you're unsure, I'm just trying to open again on this Mac.
Ben, sorry, I just wanted to let you know, I don't think that the other thing that you're trying to share is really showing. It's just your slide that's still there.
Okay. Let me, if I press that, resume share. Sharing is paused. Bring your shared window to the front. Yes.
Yeah, when you've got a few windows open, it gets a little bit complicated. But what we can do is if you talk through it,
yeah,
you want to send it to me afterwards, I can follow that up and send that out with the presentation.
I've stopped sharing, and then if I start again, it might then let me.
Yeah, sure, should work.
Let me do share screen. So is that now good?
Yeah, that's better.
Apologies. So if you didn't see much of the process tracker and just heard a lot of waffle, I'm happy to send sort of a PDF or some sort of copy out overview of what we do and how we do that. And I'll perhaps try and put it back up the end just so you can see it in stunning action. So here's kind of the example of the first notice. So make sure we cover bases. And anything highlighted in yellow is for the admin team or the block manager to update before we send out. So it's important to cover firstly the part of legislation that I'm not sure if this will highlight on here, the part of the legislation that we are writing to them about, what the project is, as much details as possible, the particular property development it's in reference to, and encompass all the particular properties in that rather than just the address of the development. So you're covering all the properties. So as you write out to each lessee, you are covering each property. And it's important just to advise that you are writing out on behalf of the client to enter into an agreement to carry out this project. Next step is to give as many project details as possible. Next step is to advise why we believe it's necessary, and dependent on the project. This one here, section 251, is about the look of the development from the outside. So it might be something that a local authority might bring action against a client if so the look of a development is failing. So it might be externals that are needed to bring the aesthetic of the block up to the look of the neighbouring properties. Most of the time, though, it will be to uphold the terms of the lease. Health and safeties, you will want to ensure that the building is compliant with fire safety regulations. So there will be changing ones. So it's important not just to keep the standard things in that third paragraph. It's important to put in what's applicable for that project. And then we advise them that they can make observations writing into the block manager in the consultation period. And obviously, depending on the date we send it, will be the date that period expires on. And then we also invite, the last paragraph, you must also invite, you have to do this in legislation, you have to invite lessees to nominate a company they feel can quote for those works. And that's as simple as that for the first notice, to cover those bases. Let me just see if I can. Hopefully it's still sharing. Sorry, my menus are stopping me doing that. So the second notice the notice of estimates will then detail out. Again, it will reference the first notice, so it ties in those dates from the first notice they received, and then we want to detail out all the contractors that the quote returned a quote, any specific additional information, whether they're not VAT registered, or if any contractors decline to quote, any information that we've got from that tender period needs to be put into that section. And we tend to run that from the cheapest contractor down to the most expensive. An important point to note, if you weren't aware, if you're new to the legislation, that you only require 2 quotes, one of which must be, and normally all quotes are unconnected, but at least one quote needs to be unconnected to the landlord. But only 2 quotes are required by legislation. So if you're only able to attain 2 quotes, or the client only wanted to go to 2 companies for 2 quotes, that's fine. But if you have more than 2 quotes, you need to list out exactly what prices you had returned back. Next, it is important then, as I said, about any contractors being connected to the landlord. The third paragraph actually then just clarifies that to the lessees, whether or not they are or aren't connected to the landlord. Point 4, we like to cover the base to make sure that any works not allowed for within the initial specification might become apparent. So they might be halfway through the project and find that some other works might be needed to actually encompass that should have been applicable in the project. In order not to disrupt the progress of the contract, we say we might need to place further instructions. However, they'll be notified of any substantial variation in costs. So that covers that base of anything else that might be needed that isn't going to be a huge cost to the development as a whole. We then advise about the retention to the successful contractor, but really importantly as well now, we don't, and I think back in the day, maybe companies did used to do this, but it's very important not to make any kind of advise who you feel you might be going with or who you are going to be going with, because that makes the entire second notice consultation period completely superfluous. It should be kept completely. There should be no information as to any contractor you may wish to or are going ahead with. As I say, it just completely takes away that need for the second consultation. Within that consultation period, you might well get further information either from a lessee's concern or something further in that consultation period that actually then makes the quote that you're going to go with non-applicable. So it's really important not to make any statements as to who is going to be doing the works at this point, because I would, from experience or from knowledge of reading other cases, I think the tribunal do take quite a dim view of carrying out the process, but then also disregarding the process of saying we're going to go with this person anyway, regardless of what anyone says. So again, we then invite people to make written observations, and then there's some decisions to be made against the first notice, whether we had any written observations, and if we did, what they were. And then finally, we like to advise people if we feel it's going to be wholly covered by reserves, or whether it's going to be a partial or a full levy that's going to need to go out to residents. So they have all the information, and that helps them then with any queries that they have coming back within the consultation period. We might as well close off those bases straight away rather than inviting several lessees to contact us at once asking how it's going to be paid. We might as well say this in the notice and cut out all that additional workload of people coming back to us. And then we also always within the notice like to include any notes that again further help lessees cover the bases and not really need to come to us as any sort of unspecific queries. So that is the second notice. I'll just run through a couple of the other ones. And when we do have, as I say, within our process, let's try to expand this if you can still see. Within our process, obviously, as I've touched on, we've got the third notice of awarding a contract. I'll just quickly open that up so we can go through that one. So again, we make reference to the project, the development, the second notice and what date that expired. And then we advise action upon instruction from the client. Although they did not supply the most competitively priced tender, this contractor has been selected to carry out the works for the following reasons. So we advise who's got the contract and why that is the case, why we feel that is the best quote, even though it's not the lowest. And then we go on to advise of any observations that we did have in the consultation process. And as I said earlier, it's important now, if we're sending a third notice, to advise how it's going to be paid for. And if it is an additional levy, as we revised in the second notice, we can then look to bill out those contributions, so we can start to have that money come in before the project is due to start. Otherwise, as I say, if those dates don't hit, we're then delaying the works, which then delays payments to the contractors and delays ultimately the admin fee to the managing agent as well. Let's just touch on the third notice. As I mentioned briefly earlier, if we then find, if you're doing it right and you're not getting the tenders until the actual tender period, you might find that the lowest contractor, the lowest quote is not does not reach the kicking point of section 20. As such, we like to write out to advise that we're awarding a contract, but that we no longer need to, under Clara 2002 here, we don't need to further consult. But we still advise of the quotes that we had in, who we're going to go with. And again, similarly to the third notice, we advise about any levies that we need to bill out. So they kind of run side by side. You'll either need a third notice if you're not going with the lowest contractor, or you'll need a start date letter that will detail who's been successful, any levy, when the works are going to start, the time frame, any CDM, that sort of stuff. Or you'll need, if the quote is under section 20, then you can send out this one and you can stop the project. I assume I might get I might get a question on this as to, if you've gone this far, what do you do about a fee then if you're stopping the process? I would say again, it's sort of client dependent. I would still suggest there is a fee due for what's taken place so far. And I would also argue that even though the consultation is stopping, because it's quite a large project, you're still going to be meeting with the contractor, you're still going to be doing the snagging, you're still going to have to organise the payments. So I would still suggest that you should be able to argue for that fee. You might need to, if you're not sending out particularly any much further correspondence to the Cs, you might agree to shave off a percentage or two. But I would still argue that you are still following a particular process within the tracker I've discussed. So I still think it's worth sort of holding firm with the client over the fee. So just before we finish on any questions, I'll just show the other ones very quickly. So this, as I say, goes hand in hand with the other two I've just opened up. This will be the award in the contract where you don't need a you don't need a third notice, and you don't need to advise you're stopping the process. This is the award of contracts where we advise the contractor we're going with, the reasons why, any observations from the second notice, and then again we advise about any levy that's due. And if any companies, as I said at the start, if it's a smaller company or companies expanding into doing more major works or unsure of any of this, because we obviously try to tie it into cram it into a small space of time, I'm obviously happy after to speak to anyone or assist with trackers, draft template notices, or to help you look at these in a bit more detail, because I know I've sort of skimmed over the notices a little bit because of time constraints. So just quickly, upon the completion of the project, we then send out the snagging letter just to advise. And these again in yellow are just to complete, again, the project as it was in the first notice, the property, sort of date stamping the other letters that were sent out. So at each point, the lessees can tie it into the last stage. And then it's just saying that the works are completed, that we're going to be doing inspections with the client or with any surveyor or project manager, but then we ask them to contact us in a small time frame to let us know of any queries. Now, there's no consultation period. We tend to try and allow 2-3 weeks tops for anyone to come back, because again, people should be able to email quite quickly, and we don't wish for that final stage to drag on, particularly where it's going to be contractors expecting to get the project done, get on to the next project and get their retention payment, and of course for us as well to be able to release our admin fee and make sure the client's happy and sign off that whole process as well. So there's just that standard template we use to invite any snagging comments. Quick one here. There might be some projects that the client decides they don't want to carry on with, or for whatever reason they've had to use reserves for some other reason, and now the reserves aren't there for the project and they don't want to levy. Well, we have a template there to advise that a project update that the works aren't proceeding, and we obviously give as many reasons as possible as to why that is, and that we'll update them in the future should the projects continue. We have a couple of projects like that, so external window projects that were due to start, but because of COVID and the worry about the safety of workmen, even though we tried to work with them to ensure they were distanced on site as much as possible, we didn't feel with the client, we agreed with the client that it wasn't safe to go ahead. So we had to put the projects on hold, and we're going to start that process again towards, because it's an external project, we're going to start the project again towards kind of December time, December, January time, to ensure once we're through all the stages, holistically, we get into that sort of May, June, fingers crossed, British summertime weather. So we don't start at a point where the weather's already good. We try and do that process before, so we know that when we're through the whole process and any delays that might occur, we're actually going to hit good weather for external projects. And then just finally, as we touched on at the start about applying to the FTT, we've also got a page of information for our team to read through to make sure before they do this letter that it is actually applicable, and we're sure that we should be applying to the FTT. But this just advises the lessees of the works we wish to carry out, the urgent quotes that we have obtained, and that we intend to proceed with the works, but that we also have applied to the FTT for special dispensation in carrying out the works. So it just details out to lessees all the prices that we have got, full reasons as to why it's necessary, and I would assume that if it's a very, very urgent project, lessees will already be fully aware of why the project's needed. And then also just details on how they might get more information from us, copies of the quotes, and just details on who's going to be carrying out the works, how quickly we intend to get them to site, dependent on that application to the FTT. But you have to be very certain that you want to make that application, you want to proceed down that road, because applying to the tribunal itself carries a cost. As we touched upon earlier, there might be costs to pay to the lessees If you've brought the case to the tribunal and it's not really applicable, they don't deem it to be emergency works. So there are lots to consider in that. But absolutely, if your roof's caving in or something like that, I would suggest that an application to the FTT is more than warranted. So that's kind of, as I say, an overview of the process in kind of an idiot's guide. I'm sure there's lots of people on here, if you're still on here, because I've talked for a long period of time, that is aware of the process. But I wanted to show you how we do that, how we keep it to a certain time frame. And what I will just do, sorry, just very quickly, that's not the one. See if I can get the tracker up just very quickly in case you didn't see that. Just as I say, just to tie the entire process up into, as I say, 25 steps, but some of these will be variable on what you need to send out. So at some point towards the middle, some steps will be either or. So you might need a third notice, or you might need to just send a contract to start letter date, and then you start doing the levies, if applicable, any pre-work arrangements, and then on through the project and the snagging and the payments of the fees. So it just covers, I'll just expand that, sorry, very quickly, just covers all the bases, and make sure when we get to the end that the client is happy to sign that off. So we have that holistic line drawn between the client's approval of starting the project and the client's approval that we've done a good job, and we can justify that fee, which, as I say, is a massive thing for a company of our size. I would suggest bigger companies as well. We have a bigger portfolio, therefore more projects to do. Hugely important to your bottom line and sustainability as a company. Okay, I will, if anyone's got any questions, if there's anyone left, happy to answer.
Yes, Ben, we do have a few questions here. Let me just see, where was the first one? Okay, so the earliest question was from Chris Wiles. Question is, in calculating the cost of works for the repurposes of Section 20, am I correct that the professional fees are excluded from the total cost calculation due to the fact that the fees for BS, building surveyors, I'm assuming that is, are not works to the building? In a similar manner, I assume that the costs of service, etc., are also excluded from the costs of the works.
So that's for a major works project, I assume. My view on it is that, although I appreciate you could argue that those fees are aside from the works, I would say always, because it's so important, I always, at Benjamin Stevens anyway, in me putting this process in place, always say it's pretty much project dependent. You know, liaising with the client, and if you're in any doubt, kind of getting some form of, if you have a legal team, or if you have a company you use for, you know, for credit control or something like that, to utilize them to see if you can just get some advice on making sure that you feel that's okay to not include that. We always do tend to try to encompass just the fees of the work, because like quite rightly says, you know, the project admin fee, surveyors fees, all of that are going to be extra to the work. They aren't actually going to be the improvements themselves. But I would definitely say proceed on a project by project basis. In the main, yes, it's the same to a project admin fee. So it wouldn't be inclusive in the works. The Section 20 kicking in point should be for the improvements, the works themselves. But dependent on your client, depending on the size of the development, I always think it's worth just making sure at the start, when you first open up the process, to just sort of tie up those kind of loose ends, or any queries that you might have. And if, as I say, if you've got somebody you can lean on for just a bit of legal advice, then do so.
Okay, next question is, our energy broker is keen to offer discounted longer term contracts, but the price cannot be held long enough to carry out the Section 20 process. Have you got any advice for getting the best out of utilities contracts?
I mean, it is an interesting question, because I touched on that earlier, that we have been looking with our brokers, and they have advised, actually, in our case anyway, with the company that we're using, that the 12-month contracts are the best route to go down, not only because the differences in the prices, again, I don't know which company that they're using or how they're going about the procurement kind of drive, but the company we're using, the differences in the prices are very minimal. Sorry, they remove the need for that Section 20 consultation, and also they do suggest, our company, that actually going year to year benefits you long term, because if you tie yourself into, say, a 2 or 3 year contract, then at, say, I don't know, 0.05 pence per unit cheaper than taking a 12-month one, you're missing out on possible benefits year on year. So there might be a better rate, or there might be another more sustainable company that comes into play at any point once you've taken that contract, that then you're tied into longer, and you're tied into 2 or 3 years. So long term, they think actually the savings are better by testing the market year on year. And the company that we're using kind of do that in the background for us, so it doesn't become a headache for us always having to, as soon as we place that 12-month contract, we're back round into the cycle of thinking, right, we need to be mindful in 6 months' time, we're going to have to start it again. We're using a company called Block Management Utilities, BMU, who I found to be very, very good. Out of the few that we've used, they're the ones really to come back to us and really push and help us through the process. Try to think to use Bionic and Octopus and some other companies. And so if you want details of that company, if you want a sort of a second opinion, then I'm happy to provide them.
Okay. So I just realised my video wasn't even back on. All right, there's another one here from Andrew. If we wanted to consult on major works, repairs and improvements, is there any time limit as to when the work should be carried out? We want to consult on a major work scheme once and then carry out the works over a 4-year period. Is this possible?
Yeah, I'd say on one project, normally if you sort of send out a notice, and that's again why I always found, as in previous companies, where there wasn't a process, you kind of can send out a notice, it slips through the cracks, and then you have to send the notice out again because it's been 6 months plus since you've done anything else. So normally in that instance, you would say, well, anything kind of under 6 months probably tops, you could get back on board with continuing the process. Although I still think it's a bit tricky, and that if you were just at the start to have a process, you should actually just bite the bullet and start the process again. For one like that, that's going to be done over time. I mean, I'll probably prefer to have a look into that and get back, because my point of view would be that it would be the same as breaking up the project. Obviously not to avoid Section 20, but breaking up the project in order to do the Section 20s at each point. But that's kind of superfluous, because if you do that and split up the works, your admin fee is going to be the same anyway once it's added up. And the projects might as well be kept as one. So I think as long as you, from the off again, are advising the lessees, any RTA, RMC, client, everybody, as long as at the start you are setting out your stall as you intend to proceed, I think that would be okay. If you knew the time frame and you could give a distinct time frame to residents and it doesn't change, if it changes, you'd need to give that advice along the way. I think as long as I say, I keep sort of saying, as long as you just try to cover all bases to say, what am I doing on the process here now, this step I'm doing, what in this step might be a possible hurdle, what might be a possible hurdle I might trip up on that is a liability to the client or the company. So I think just at every step to think what could actually possible, what's the worst case scenario. So I think if you're doing a big long project, as long as you've given people itemized outlook, and then you tell them if it changes at any point, I don't see the problem with that. But I'll have a look into that, because that's obviously a long time to stretch a project out over. And also, sorry, dragging on, but I think you'd also have to have a word with the client as well about fees over time as well. I don't think you want to wait 4 years to collect your project admin fee. So on a company point of view, you'd want to try and be able to collect some form of admin payment along the way.
Okay. Well, hopefully that answers the questions for that. There are a few more questions, but we are out of time now. So what I will do is maybe if I can send you over the questions, Ben, and then if you have time, if you can follow up with people individually, then that would be lovely.
Yeah.
But
Absolutely.
thank
I
you
mean,
very much for your time today.
that's okay. I mean, it's probably in a short space of time. There's probably bits that you need to touch on. We don't quite get there, but I think what most important thing for me was to just try and show maybe to, if there's similar sized companies, to have a process so you can get the best percentage fee you can from the client, and realize that for your company's bottom line, and not be doing projects and stuff like that for free.
Yeah, absolutely. Okay, well, the recording will be sent to everybody, and if anyone has missed the session, I'll also be sending that out to them with a copy of Ben's presentation. We do have some more webinars coming up in the next couple of months. So if you take a look on the website, feel free to register if you're interested in joining us. We also have our first live knowledge bank, which will be taking place in Birmingham on the 9th of September, which is in association with L. Kendrick Building Surveyors and Realty Law. So if you are interested in joining us in Birmingham, then please do go onto the website and register your place. Other than that, thank you very much for your time today, Ben. Hopefully we'll see you again for another webinar soon.
Thank you. Appreciate that. And I've just opened up the chat and I've seen some of the comments, people desperate to see the process tracker. So apologies, because my first one, I was so trying to get things on the screen, I wasn't even looking at the chat.
Yeah,
so,
it's hard to look at your screen share and the comments and stuff at the same time.
But yeah, hopefully everyone saw everything to a degree, and I'm happy to help. If people want a hand with anything along the way, then just get in touch. Okay,
sure. I'll be sending out your contact details anyway with the presentation. So Brilliant. If anyone wants to contact you, then they'll have your information there.
Brilliant.
Okay, thank you very much. Enjoy the rest of your day.
You too.
Bye.
Thanks all.